Mr. President, thank you so much for having me here today. Thank you for that nice introduction. And thank you especially to Advocates for Balance at Chautauqua. You are doing very good work at the institution, and you need to know that this entire community appreciates that good work that you're doing. So thank you very much. Today we're here to talk about the constitutionality of law regulating political speech. But first, let's get a feel for the audience a little bit. Is there anyone here who by chance has ever been involved with maybe a candidate's political committee, a candidate's campaign committee, or maybe a political party, or maybe an organization that really is a political committee, a political action committee is sometimes the label for that, where you had something to do with the raising or spending of money? Okay. Well, I see a few hands here, so all of you will know what we're talking about here today. Let's back up a little bit. We're going to talk about some Supreme Court opinions, and let me toss out a few names, and you don't need to raise your hand, but just ask yourself if any of these names ring any bells. Buckley, Citizens Against Rent Control, California Medical Association, Bellotti, Massachusetts Citizens for Life, Austin v. Michigan Chamber of Commerce, McConnell, Wisconsin Right to Life. Here's one that will ring bells, Citizens United, McCutcheon. If any of those ring a bell at all, you're in the field of political speech law, and particularly political speech law as it relates to the First Amendment. Now let's back up a little bit here again and make sure we're all starting at the same place. This is a little like following directions on MapQuest, and we're going to follow directions from A to B. And if we don't start at A and we follow directions to B, we're not going to get to B. So let's make sure we understand where A is. In America's mother country, that is in the United Kingdom, the default setting on government, just like you have a default setting on your computer or on your telephone, the default setting is that all power lies with the crown, and that government, that is the crown, dispenses liberty by its grace. The default setting is that government has all power and the people have none. The people have power to the extent that the crown, the government, has allowed people to have that power. Now ask yourself, is that the default setting in the United States? If you said no, you're right. What are the first three words of the United States Constitution? First three words of the United States Constitution, you know, are we the people. In this country, we have the opposite default setting. All power lies with the people, and government has only those limited and enumerated powers that we, the people, yielded to government in the first place. That goes for the federal government, that goes for the state government, that goes for any subordinate governments at all. Government has only those powers that we, the people, yielded to government in the first place. One of those powers is the power to run elections. And it follows if government has the power to run elections, it has the power to make them run well, right? That makes sense. There are limits, though, even on government's limited and enumerated powers. Some of those limits, you know, are in the Bill of Rights. And in the First Amendment, one of the rights that people have is the right to freedom of speech. So government has the power to run elections and the power to make them run well. And the people have a right to freedom of speech. So you see, right from the beginning, there's a tension. What about when people engage in speech about elections? May government do just anything it wants to in the name of running the elections well? Or do the people have rights to freedom of speech that supersede government's power to run the elections well? Are there boundaries around government's power? Well, yes, there are boundaries around government's power. And speech, remember, the freedom of speech has different levels. Political speech is at the very core of what the First Amendment protects. Now, you've heard of other kinds of speech that the Supreme Court has addressed. Flag burning, cross burning, nude dancing, dirty movies. There was even a case from California one time where a man walked into a state courtroom, and this was in the Vietnam era, wearing a jacket that said blank the draft. Now, I'm not going to tell you what word goes in the blank, but let me assure you that the word you thought of when I said blank, that's the word. And if you're thinking to yourself right now, oh no, don't tell me there really was a Supreme Court case about that word, so I must be thinking of the wrong word. I assure you, you are not thinking of the wrong word. And the more you doubt that you're thinking of the right word, I assure you, you're right. Well, it's political speech. And political speech, unlike all those other things, flag burning, cross burning, nude dancing, all the other stuff, is at the very core of what the First Amendment protects. Now let's talk about people's First Amendment right to political speech. There are two types of law regarding political speech. This is fairly simple. One concept involves banning or otherwise limiting political speech. And another concept involves regulating political speech, and regulating involves requiring disclosure in various forms. Now, all of these principles, whether we're talking about bans or other limits, and a ban, you know, is just a limit of 0, right? A ban is a limit of 0. Or whether we're talking about regulation, which we'll talk about in a moment, apply to all organizations on all sides of all issues. Maybe the organization is a small group of neighbors. Maybe it's a large employer. Maybe it's a union. Maybe the organization is incorporated. It doesn't matter. These principles apply to all organizations on all sides of all issues. Now let's talk about briefly about bans or other limits. This isn't our primary topic today. Our primary topic is regulation and a particular type of regulation. But briefly, let's talk about bans and other limits. Under Supreme Court case law, the only permissible justification for banning or otherwise limiting political speech, whether it's in the form of spending or contributions, is the prevention of what's called quid pro quo corruption of candidates or office holders, or the appearance of quid pro quo corruption of candidates or office holders. Quid pro quo simply means an exchange. It means this for that. There has to be an exchange. Justice Breyer once called this an act akin to bribery. That's the only justification for banning or otherwise limiting political speech. When spending for political speech is independent, the Supreme Court has held. That is, when it's not connected to candidates or office holders, when they're not involved in the speech, when the speech isn't coordinated with them in any way, then there is no possibility of quid pro quo corruption or the appearance of quid pro quo corruption because the candidates aren't involved. There's no connection to candidates and therefore no quid pro quo corruption or the appearance of quid pro quo corruption. That means that government may never limit, never, ever, ever limit independent spending for political speech. It also means that when an organization receives contributions for independent spending for political speech. There's also no connection to candidates or office holders. That means government may not limit contributions for independent spending for political speech either. That's what we're going to say today about bans or other limits. Now let's turn to the main subject we have today, that is regulation of political speech. And don't be confused by the word regulation. In this field of law, regulation does not mean a ban or a limit on political speech. It means disclosure. Regulation in this field of law means disclosure. Sometimes people mix up those words. Don't let that confuse you. Regulation means disclosure. There are three different types of regulation, and you know what these are. One of them is an attribution. One of them is a disclaimer, and one of them is reporting. You know what attributions and disclaimers are if you hear radio ads or watch television ads during election season. Paid for by the independent citizens to elect Paul Anthony President of the United States, not coordinated with the Paul Anthony for President Committee. The first part of that is an attribution. It says who's speaking. The independent citizens are speaking. Not coordinated with Paul Anthony's presidential campaign is a disclaimer. It says who is not speaking. Attributions, disclaimers. Then there's reporting. Those of you who raised your hand before when I asked if anyone had ever been involved in a candidates committee or a political party or an organization that really is a PAC where you had something to do with raising or spending money know very well what reporting is. Reporting is when you fill out forms for the government and submit them on various schedules. And there are different levels of reporting. And we'll talk about that when we go along. Now, regulation, remember, means disclosure. And the Supreme Court has permitted government to regulate, that is, require disclosure of political speech on two separate tracks. And they're distinct analyses because they're distinct types of burdens on political speech. Track 1 burdens are much heavier. We'll talk about those in a moment. But Track 2 regulation is the one we'll talk about first, because there's a concept here that we need to apply when we talk about Track 1. Track 2 regulation requires reporting, and it's burdensome reporting, but it's not nearly as burdensome as the kind of reporting that occurs under Track 1. And the Supreme Court has permitted government to regulate, that is, require disclosure of political speech on Track 2 with respect to two types of political speech. One is called independent expenditure. Independent expenditures are a term of art in this field of law. Expenditure means speech that says vote for or vote against this person or this ballot measure, this referendum, or something like that. It doesn't have to use those exact words, but it has to in some form say vote for or vote against this person or this ballot measure. And it has to be independent of the candidate. That is, not coordinated with the candidate. So an independent expenditure is express advocacy, speech that expressly advocates for or against a candidate or a ballot measure and is independent of the candidate or the ballot measure. That concept comes from the 1976 decision in Buckley versus Vallejo. There's a second type of political speech where the Supreme Court has permitted regulation with Track 2 type regulation. That type of speech is called FECA, Federal Election Campaign Act, electioneering communications. Now that's a fancy term for what simply means this: broadcast speech that occurs in the 30 days before a primary or the 60 days before a general election, has a clearly identified candidate, and is targeted to the relevant electorate. So if you run in the 60 days before an election, a general election, a message telling Senator X, who is a candidate in that general election, to vote for this or that issue, and that issue is targeted to the relevant electorate, that is, to where people can vote for or against Senator Smith, Senator Smith or whoever the senator is. That's a FECA electioneering communication. That concept comes up most recently in a Supreme Court decision called Citizens United. These are the two types of political speech where government has permitted regulation with Track 2 regulation, where the Supreme Court has permitted government to regulate political speech with Track 2 type regulation. Hold on to this thought about independent expenditures, because we're going to come back to that.
Okay, we're rolling.
Now let's talk about Track 1 regulation. Track 1 regulation applies when it's constitutional to make an organization be a political committee. These burdens are much heavier than what government may, under Supreme Court case law, trigger under Track 2. So what may government trigger when it's constitutional to make an organization be a political committee? And those of you who raised your hands before for having been involved in these kind of things will know what this is. One is that an organization has to register with the government. What does registration involve? Well, you have to fill out the form identifying yourself. You may also have to get a bank account. You may have to appoint a treasurer. And when you're done engaging in political speech, you have to shut down your committee. You have to wrap things up, maybe empty your bank account, fill out more forms, and terminate your existence. You also have to keep records. If you've been a treasurer of a political campaign, you know what that means. You have to keep track of everything that comes in and everything that goes out. You also have to engage in reporting that's way more extensive than what occurs under Track 1. In the first place, the reporting is ongoing. It doesn't just occur in the reporting period following political speech. It occurs in every single reporting period, whatever that is. Maybe that's quarterly, maybe that's so many days before an election, maybe that's so many days after an election, whatever government requires. It's ongoing reporting. It's not just reporting that occurs only in the period for which speech occurs. In addition to that, the reporting is extensive. Track 2 reporting looks like your checkbook. Extensive reporting, which occurs under Track 1, looks like an accountant's balance sheet. And it can be very complicated. You have to carry things forward, you have to total things up, and you have to keep on going with all of these burdens. Now, what's wrong with these burdens? Well, it's fine when they're constitutional. But there are limits on when they're constitutional. And the reason that there are limits on when they're constitutional is that these burdens, in the Supreme Court's words, are so onerous that some organizations, particularly less wealthy organizations, will sometimes just throw up their hands and say, forget it. If we have to do all this stuff, we're not going to engage in our political speech. And I've had the privilege of representing people and organizations that were in this position. They said, if we have to do all this stuff, if we have to register with the government, if we have to get a bank account, if we have to have a treasurer, if we have to file termination papers when we're done with our speech, if we have to engage in record keeping the way the government tells us to, it's fine for us to do our own record keeping, but if we have to engage in record keeping the way the government tells us to, and if we have to file reports that are both extensive and ongoing, then forget it. We'll shut up. And when people have to shut up, we have lost speech that, remember, is at the very core of what the First Amendment protects. And that's why this kind of reporting can be dangerous. The Supreme Court has rightly responded to that by limiting government's power to trigger Track 1 regulation. So now let's talk about when government may trigger Track 1 regulation. And when government may trigger Track 1 regulation, it's perfectly fine for government to do that. But there are definite limits on when government may trigger Track 1 regulation. So when is it constitutional for government to trigger these kind of Track 1 burdens for organizations engaging in political speech? When is it constitutional for government to make an organization be a political committee? Well, the Supreme Court has answered that question. Number one, it's constitutional to make an organization be a political committee when the organization is under the control of a candidate or candidates. So that's a candidate's political committee. Somebody is running for Senate or Congress or a state office and has a political committee, has a campaign committee. It's constitutional to make that organization be a political committee and subject to further inquiry, which we can talk about if you have questions about that. Comply with these burdens. When else is it constitutional? Suppose an organization is not a candidate's political committee or a political party. Is it ever constitutional to make the organization be a political committee? Well, yes, under some circumstances it is. It's constitutional to make such an organization be a political committee if it has what's called the major purpose of nominating or electing candidates or passing or defeating ballot measures. And if the organization engages in more than small-scale speech. We'll come back to that in a minute. So when does an organization have the major purpose of nominating or electing candidates or passing or defeating ballot measures? Well, you can look at the organization's organizational documents and its public statements. Notice it's public statements, not private statements. We're not going around fishing in people's private statements. Think of the old Supreme Court cases from the 1950s and 1960s involving the NAACP. We don't go snooping around in people's private membership lists. If an organization says in its organizational documents or in its public statements that it has the major purpose, well, government will take its word for it, and that's okay. Well, suppose it doesn't say that in its organizational documents and public statements. It still has the major purpose, and remember, major, that's the root of the word majority. So if the organization devotes the majority, that is more than half, of its spending to contributions to candidates or ballot measures, or, remember this phrase from before, independent expenditures for candidates or ballot measures. And you remember what independent expenditures mean. That's express advocacy that's not coordinated. If the organization devotes more than half of its spending to contributions to or independent expenditures for candidates or ballot measures, then the organization has the major purpose of nominating or electing candidates or passing or defeating ballot measures. Now, let's go back up to this small-scale speech concept. Suppose you have two nerdy little kids in a lemonade stand. This is my favorite example. And they, on a summer afternoon, sell lemonade. and they, for whatever reason, decide to devote their entire, or more than half, of their princely sum of $10 for the afternoon to independent expenditures for or contributions to the local candidate for whatever. Well, technically, those little kids just triggered the major purpose test, right? Because they devoted more than half of their spending to contributions or independent expenditures. Well, that's dumb. That's dumb, right? Who cares what those little kids did? Or if an organization spends a few $100s, or maybe even a few $1,000s. Those situations have come up in a couple of different cases. And the point is, at that low level, at the level of small-scale speech, who cares? So an organization that has the major purpose, but engages in only small-scale speech, doesn't have to be a political committee, even if it trips the majority of spending threshold. Well, now think about that from the other angle. Suppose that an organization, and let's just pick a ridiculous example here, is a $1 billion organization, whatever that may be. And it wants to spend a lot of money on contributions or independent expenditures, but instead of spending more than $500 million, that instead of going above half, it keeps it to $490 million, or $480 million, or $400 million. That organization would not have to be a political committee under this formula. But an organization, and this is fairly common, that's say a $100,000 organization that may spend $51,000 of its budget on contributions or independent expenditures, would have to be a political committee. So here's my proposal, and this is my proposal, and it's written in the Law Review article we'll talk about in a little bit. If an organization devotes a massive amount of money, a mass amount of its spending to contributions or independent expenditures, whatever that means, but it needs to be an objective, easily understood, verifiable standard, then it's okay to make that organization be a political committee, even if that amount of spending is less than half. Now, this is all simple enough. What's the problem? Because the federal courts of appeal and a few state Supreme Courts are all over the place on these issues and have come out with very different results in the last, that is, since 2010. What's the problem? Here's the problem. Citizens United is the problem. Let me repeat that in case anybody thinks I just misspoke. Citizens United, or more precisely, misinterpretations of Citizens United, are the problem. What's the misinterpretation of Citizens United? Remember we were talking before about under Track 2? Citizens United allows limited Track 2, not Track 1, Track 2 reporting of Federal Election Campaign Act electioneering communications. That language has flowery language, that part of the opinion has flowery language, broad language about disclosure. Now it's only talking about Track 2 disclosure, not Track 1 disclosure. But some courts have taken that part of Citizens United and said that it overrules all of this stuff and that all kinds of disclosure are okay, even Track 1 disclosure, even for organizations that don't have the major purpose or aren't under the control of a candidate. That's essentially the divide among the federal appellate courts and among state Supreme Courts. And that's the problem that the Supreme Court has not taken up yet. They've had a few chances. They haven't taken that case yet. Now let's talk about who benefits from this type of law. Who benefits from Track 1 law? And when I talk about who benefits from Track 1 law, I'm not talking about in any way questioning anyone's motives. I'm not questioning anyone's motives. Why don't I have to question anyone's motives? Can you think of why? Here's the answer. Do you see motive up here? It's not relevant. Motive doesn't matter. Motive isn't part of this analysis. I don't have to question people's motives, and I'm not doubting people's motives. But there are some people who naturally benefit from this kind of law. And it quite naturally is not going to occur to people who benefit from this law to challenge its constitutionality with this kind of analysis or any kind of analysis. It's just not going to occur to them. And that's not surprising. So who benefits from this law? Who benefits from this type of law? Well, for one, people like me benefit from this type of law. Why? Because if people want to engage in political speech, they have to make sure they don't get in trouble with the law, because you don't want to get in trouble with this law. It means civil fines. If you really screw up, it can mean criminal prosecution. And you never, ever, ever want to play defense against the government in this field of law or in any field of law. You don't want to play defense against the government. So people like me benefit from this type of law. Is it any wonder then that it doesn't occur to some people? And again, let me emphasize this. I'm not questioning people's motives. Don't think to challenge the constitutionality of this type of law. It simply doesn't occur to most people. Who else benefits from this law? Well, people who civilly enforce or criminally prosecute such law. They make their living doing this. It quite naturally doesn't occur to them to think to object to the constitutionality of this law. That just isn't going to dawn on people. Who else benefits from this law? Politicians benefit from this law. Why? Because when people engage in political speech, they sometimes criticize politicians who want to be reelected. If the burdens are so onerous on speech that people throw up their hands and say, forget it, we're not going to engage in our speech, we're going to shut up, politicians are going to be criticized less. Right? Less political speech means less criticism of politicians. Politicians like that, especially election time. It quite naturally isn't going to occur to them to think that this law shutting people up is a problem under the Constitution. Quite naturally isn't going to occur to them. Who else benefits from this law? The rich benefit from this law. Many times, and particularly people on a certain side of the political spectrum, and you know which side this is, are constantly denouncing the rich and saying, we need more laws like this to protect us from the rich, particularly corporations. Well, whether an organization is incorporated has nothing to do with where an organization falls under this law. But think about this further. Is law like this really protecting us from the rich? Well, people with lots of money, whether they're individuals or organizations, can afford to go out and hire people to protect them from this kind of law, to make sure they're complying with this kind of law, so that they don't subject themselves to civil fines or criminal prosecutions. Who can't afford to do that? Less wealthy people can't afford to go out and hire people at $250 or $500 an hour just to engage in political speech. Imagine you're running a $100,000 organization. Do you think you're going to put into your budget paying someone $250 or $500 an hour to make sure you don't trip these political speech laws? Or are you just going to shut up and not engage in your political speech? You're going to be quiet because it's not in your budget if you're not a wealthy person or a wealthy organization to protect yourself from these kinds of laws and make sure you don't violate them and expose yourself to civil fines or criminal prosecution. The way this law, in effect, protects the rich is the most insidious aspect of this law. And what it does is shuts the little players out of the marketplace and to some extent leaves big players as the only players in the marketplace of ideas. The marketplace of ideas involving political speech, which is at the very core, remember, of what the First Amendment protects. The very core. And with laws like this, not protected by the Constitution, not protected by what the Supreme Court has enunciated, big players, wealthy players, can have the marketplace of ideas much more to themselves than they otherwise would. And that, as mentioned, is the most insidious aspect of this law. If you're looking for any additional information on this, please feel free to contact me at 202-423-2122, 202-423-2122. Or, if you like, you can read this law review article of mine from the Regent University Law Review. The site is 29 Regent University Law Review. The year is 2016. The first place I'd start reading is the text, not the footnotes, the text through part 5. The text of the entire law review article is only about 5,000 words. The footnotes, and if you've read law review articles before, you know that this is common, are 25,000 words. And they get way, way, way deep into the weeds. So read the text. If you want more information, read the text following part 5. First through part 5, then following part 5. If you really want more information after that, then read the footnotes to whatever extent it suits you. Maybe in those places where you're looking for additional information. 29 Regent University Law Review 35. Now let's talk about what you'd like to talk about. Are there questions that the audience may have?
I've heard of the functional equivalent of express advocacy. Does that come into play here?
The question goes to a concept in law that originated several years ago called the functional equivalent of express advocacy, and it's more commonly called the appeal to vote test. And the question is, does it come into play here? The answer to that question is no, and it doesn't come into play anywhere in the law anymore because the whole concept of the functional equivalent of express advocacy is dead. Totally dead. The Supreme Court in Citizens United effectively killed it off. And if you want to look at more about that, please look at this law review article, and it's part 6, 29 Regent University Law Review 35, and Part 6, and that explains why the appeal to vote test, formerly known as the functional equivalent express advocacy, is dead. It's gone. It's no longer part of the law, and nobody should use it in constitutional law, and nobody should ever write it even into a statute the legislature passes anymore, or a regulation that a regulatory body enacts, ever. It's gone. It's dead. Anything else?
How do organizations challenge the constitutionality of political speech law?
You file a lawsuit. Go to your friendly neighborhood lawyer and file and explain what you'd like to do. And then you file a complaint. You can do that either in a federal court or in a state court. It's usually done in a federal court, but you don't have to. And there are a couple of approaches you can take. One approach is that you can say, gee, I've already engaged in this political speech, and I violated this law. Let's go have this law enjoined. That is, have a judge put the brakes on this law so because it's unconstitutional, so that it can't be enforced against me. That's one approach. Another approach is to say, as some of my clients have done, look, Judge, we want to engage in this political speech. But we know that if we engage in our political speech under the law of whatever jurisdiction we're in, we have to comply with all of these burdens. And it's unconstitutional to make us comply with these burdens. So please, Judge, stop this law, put the brakes on this law, and join the enforcement of this law with respect to us so that we can engage in our speech without having to comply with this law. That's a couple of ways to do it. Anything else?
What is your favorite victory?
Victory? I think my favorite victory involves a case in the Seventh Circuit Court of Appeals. The Seventh Circuit, you may know, covers a few states in the Midwest, including Wisconsin. And this case involved Wisconsin law, and we won a huge victory against Wisconsin law. The decision, written very admirably by Judge Diane Sykes on the Seventh Circuit, is very well done. It's not perfect because it incorporates, we were talking before about the functional equivalent of express advocacy, the appeal to vote test. It incorporates that concept, and it shouldn't have. Other than that, it's very well done. Now let's take whatever questions the rest of the audience may have. And thank you for joining us today.